Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss the importance of Section 52A of the NDPS Act in seizure of the material, taking samples of the material. If you don't do it, that means if the police officer doesn't follow the procedure envisaged under 52A of the NDPS Act, entire proceedings will be vitiated. So the conviction previously given was set aside in the shape of appeal. This is what you have to know from this case. Now, the case is Simranjit Singh versus State of Punjab in criminal appeal number 1143 by 2023, dated 9/5/2023 by two judges bench. Honorable A.S. Voka, that is Abhay Srinivas Voka, and Rajesh Bindal. Please remember, they reiterated that if the samples are not taken in the magistrate presence, in the presence of the magistrate, definitely Section 52A is violated and the conviction given, if at any, it will be done away with. Now, that means you have to understand that drawing samples should be done in the presence of the mediators as per Section 52A, and the process has to be certified by the magistrate to be correct. Coming to the facts of the case, the appellant, that is Simranjit, others, three others totally, only this man has come from appeal. They were caught red-handed while traveling in a tempo. So, the officer, that is the SI, Hardeep Singh, and his staff, other police officers, they were conducting searches near a bridge in a village called Balak Khurid. So near that village, they are conducting the search. And at that time, they noticed a tempo coming in the opposite directions. They stopped it. Ultimately, they found, 8 bags of poppy husk. They found 8 bags of poppy husk. So that was recovered. Actually, they were covered under polythene bags. Whatever it is. So during the night, that is 43 of the NDPS Act. So the search was conducted, and immediately the superintendent of police was called, and the search was conducted in the presence of SP, and 8 bags of poppy husk was recovered. At the same time, they have drawn 2 samples of 2 to 50 grams each of the seized poppy husk and sent the same to the laboratory, forensic science laboratory, which certified that they are from cannabis sativa or they are from the ganja family. He was convicted. Now the matter went in appeal. So actually the matter was first appealed before the High Court. High Court dismissed the appeal, and as such the matter came to the Honorable Supreme Court of India by filing SLP. That was also decided on 9/5/2023. So, friends, remember, in this case, only one technical or legal point regarding Section 52A was raised by advocate on behalf of the appellant. So, Section 50, he has relied on the very famous case of Union of India versus Mohanlal 2016. Mohanlal and other 2016. So, please remember, there also the case was acquitted because the procedure was not followed as per Section 52A of the CRPC. 52A of the NDPS Act, I'm sorry. Right. So, the police officers are authorized to conduct the search, to conduct the power of, they have got the power of search and seizure as per Section 43. That is, in any routine checking of vehicles. Then 52A, most important section being discussed here. Therefore, please remember 52A subclass 2, where any narcotic drug has been seized and forwarded to the officer in charge of the nearest police station. Right? So, please remember, so immediately the SHO shall prepare an inventory of such narcotic drugs. So after seizure, he has to prepare an inventory and convey the same to the nearest magistrate for the purpose of certifying the correctness of the inventory prepared. Already has prepared the inventory, but whether it is correct or not. Number 2, taking the photographs or taking the samples, right? Taking the sample or drawing the samples in presence of the magistrate, and the magistrate has to certify the correctness of any list of the samples so drawn. That means it is the primary duty of the investigating officer to prepare an inventory, then produce the material before the magistrate and draw samples in his presence. So was it done? No. So ultimately, failure of drawing of samples before the magistrate is taken very seriously by the Supreme Court, and they said that this process is not free from suspicion. Therefore, they allow the appeal. Case has gone. Right? They will be useful definitely for the so-called defense advocates. So please read the judgment, and definitely you will be enlightened with the provisions of section 52A of the NDPS Act, and also you will be enriched with the legal knowledge. Thank you.